Good afternoon and welcome to this, the first of the Hardiman series of lectures. And can I say it's a particular pleasure for me to be able to deliver a lecture in the series devoted to my sadly late but long-standing friend Adrian Hardiman. And I'll come back to mention him in an interesting way in the context of the lecture. As the title of this lecture refers to observations, I might say that I think a proper analysis of the questions which could arise in relation to the constitutional and court structures of the United States on the one hand and the European Union on the other would warrant a full year lecture course or perhaps a detailed master's programme. So what follows are some personal observations from my own experience and knowledge of both systems, though obviously my experience of the European system is direct and my knowledge of the United States system is more gleaned by osmosis from contact with American lawyers over the years. But it might make sense to start by setting out what that experience is. I qualified as a barrister in 1973 and I was very lucky to become, within a short number of years of starting practice, the junior counsel in a major constitutional case called Healy versus Donoghue. And as certainly many of the Irish students will know, that case established a constitutional entitlement for the provision of legal aid to those who were charged with serious criminal offences and who were impecunious. And my particular job in that case was to research the United States jurisprudence stemming back to cases such as Gideon versus Wainwright. And in the late 60s and early 70s, there had been a number of Irish constitutional cases in which the Supreme Court had paid attention to the way in which the US Supreme Court had developed its jurisprudence when considering rights that were common to both the United States Constitution and the Irish Constitution. And the Irish Constitution provided, still does provide, that persons should not be imprisoned, and the phrase is used, except in due course of law. And that language is obviously not dissimilar to the due process provisions which are set out in the 14th Amendment to the US Constitution. And we wanted to put forward an argument that suggested that the Irish Supreme Court might interpret the due course of law phrase in our Constitution in a way similar to the way in which the United States Supreme Court had developed the due process jurisprudence. And that meant researching United States constitutional law in that area. And that was my first, formal introduction to the constitutional law of the United States. And it's interesting to note that the Irish Supreme Court, in the course of its judgment, did pay attention to that US jurisprudence. And if we look at the judgment of then Chief Justice O'Higgins on page 351 of the report, having made some references to the position under the European Convention on Human Rights, he goes on to say, in the United States of America, the development of judicial opinion on the meaning of the right to due process guaranteed in the 14th Amendment has reached a similar conclusion. In Gideon versus Wainwright, the Supreme Court of the United States held that in a criminal trial for a serious offence, the right of an indigent defendant to have the assistance of counsel is a fundamental right which is essential to a fair trial, and that a trial and conviction without such assistance violated the 14th Amendment. In more recent times, I've been involved in a number of initiatives, such as this placement programme, but also exchanges with law schools in Chicago. And I've been invited to speak at a number of conferences in the United States, and I've come to a much greater understanding of the big picture issues that arise in constitutional and legal sectors across America. It's inevitable that when lawyers and judges from different jurisdictions get together, that discussions frequently centre on comparisons between how similar questions are dealt with in different jurisdictions. Contrast and comparison between Europe and America is an inevitable topic. Now turning to Europe, in the same year that I was called to the bar, 1973, Ireland joined what was then the European Economic Community. Ireland had been earlier, since the 1950s, one of the first subscribing states to the European Convention on Human Rights. And it's perhaps important for our American students to understand that the Convention on Human Rights is nothing to do with the European Union, but rather is a convention entered into by the states of the Council of Europe. The Council of Europe, the Court of Human Rights are not the same thing as the European Union, and equally the courts of the European Union are not the same thing as the courts of the European Convention on Human Rights. And the Council of Europe, not the European Union, is a wider body containing many countries outside of the European Union, such as, for example, Russia and many of the former Soviet states, together with other countries like Iceland. Indeed, it's interesting that Judge Spano, the current president of the European Court of Human Rights, is himself an Icelandic judge. And thus I have been around, I suppose, during all of my legal career, during the development of the Irish engagement with the law both of the European Union, which is largely binding in Ireland, but also the case law of the European Convention on Human Rights, which is highly influential, as we even saw back in the case of Healy, but not strictly speaking binding. And I was lucky enough as counsel to appear on a number of occasions before both the Court of Justice of the European Union in Luxembourg and also the Court of Human Rights in Strasbourg. And this is an interesting historical figure. One of the leading Irish cases before the European Court of Human Rights was the case of open door counselling and well-woman against Ireland. And that was a case that arose out of orders that were made in Ireland after the so-called Eighth Amendment, which outlawed abortion, which went further and placed injunctions against societies or bodies giving advice or counselling to women who might wish to travel abroad, mainly to the United Kingdom, to obtain terminations which were lawful in that country. And such orders were made against our submissions in both the High Court and the Supreme Court of Ireland. The case was brought to the European Court of Human Rights. And first, certainly from our perspective, unusually at the time, photographs were taken in the court. And it may be just of some interest to note counsel's bench on that day before the European Court of Human Rights in the open door case. The two to the right were the two counsel appearing for well-woman. The two to the left were counsel appearing for open door. And from the right, the first is Brian Murray, then a junior counsel, but now a distinguished judge of the Court of Appeal of Ireland. The second is my late friend Adrian Hardiman, who was lead counsel for well-woman. And it's striking perhaps to have that photograph with us today, given that this lecture series is being delivered in his honour. Third is myself. And the fourth is an interesting additional member of the legal team, one that may be of particular interest to our American students. Unfortunately, the researchers of the Bar Council from whom this photograph came were unable to identify him, and he's just described as unknown. In fact, he is, I think, very well known. His name is David D. Cole. At the time, he was part of the Centre for Constitutional Rights in New York. He subsequently became Professor David D. Cole, the George J. Mitchell Professor of Law and Public Policy at Georgetown, up to 2016. And since then, he has been the National Legal Director of the American Civil Liberties Union. And he was then perhaps a younger, as we all were, lawyer who occupied what I think in American terms might be called the second seat in the legal team representing Open Door. And I might just add, because you're entitled to boast a little bit, that we won that case before the European Court of Human Rights, and the position in respect of counselling and making arrangements for travel for women wishing to have terminations abroad was changed as a result of that. In more recent times, however, the involvement of the Irish Supreme Court and in various representative bodies for Supreme Courts throughout Europe has led to an increased interaction and understanding of the various systems within Europe, and in particular the European Union, and how they interact. Many European countries have separate Supreme Courts for a range of things, Supreme Courts for ordinary cases, Supreme Courts for public law or administrative law, and very frequently a separate court or tribunal for constitutional matters. And therefore there are separate European representative bodies for each of those streams of courts. And these various experiences have led me to some general views on both the similarities and the dissimilarities between the structures and systems on either side of the Atlantic. And the observations which follow reflect some of those views. I propose to start at the top. The United States has, of course, a constitution. During the noughties, there was a proposal that the European Union might also adopt a constitution. And a treaty establishing a constitution for Europe was signed in 2004 on behalf of what were then the 25 members of the European Union, and were ratified by 18. But the project ran into difficulties when it was defeated in referendums in both France and the Netherlands in 2005. A less ambitious project involving rewriting the existing treaties of the European Union led to the Lisbon Treaty, as a result of which we now have three quasi-constitutional documents. One is the Treaty on European Union, the second is the Treaty on the Functioning of the European Union, and the third is the Charter, which deals with rights guaranteed as a matter of European law. And I think it can fairly be said that taken together, those three documents, while not amounting to a constitution, do have many similarities with a constitutional regime, including, as they do, provision for the basic political structures of the state or group of states in this case, and the Charter, which is the equivalent of a Bill of Rights. So whatever about technical definitions, it seems to me to be possible to consider the European treaties collectively as amounting in practice to something which is close to a constitution. So how then do those treaties or constitutions on either side of the Atlantic compare? Perhaps a preliminary point might be to say that I've always felt that major new political ventures lead to arrangements which don't always neatly fix into theoretical boxes. In the last quarter of the 18th century, the United States was certainly a major new development of that type. And as an outsider, its structures and institutions often seem to me to reflect, at least in part, the tensions present at that time. The position of the president, the checks and balances between president and Congress reflect this. And so too does the fact that both houses are elected in very different ways, with the states having equal representation in the Senate, but the House being largely based on proportionality so far as population is concerned. And those balances reflect the issues of the day over 200 years ago, but they also, as we have seen in recent times, also influence the situation today. Interestingly, the European Union has developed perhaps in a not entirely different way. There are in substance three significant institutions involved in making laws in the European Union. The European Commission is sometimes referred to as the European Civil Service, but I think that only partly describes its role. It also has a much more formal status in proposing legislation and in ensuring compliance by the member states with the law of the European Union. So it's, I think, a lot more than a European civil service. I think it would be to underestimate its role in so describing it. And I don't believe that there is an equivalent institution within the United States constitutional order. However, the two other institutions which must formally adopt legislation are, at least for most cases, the Council of Ministers and the European Parliament. The Council of Ministers consists of a relevant minister from each member state, depending on what types of issues are being debated, or in the case of the European Council itself, the Prime Minister or equivalent from each state. The Council of Ministers mainly operates on a quite complex voting system, although in practice many of the decisions are ultimately made by consensus. However, while the weighted voting system gives more votes to bigger countries, the situation is far from proportionate. For many of the decisions of the European Council, a so-called qualified majority is required, which means that 55% of the states, and in that calculation, every state, no matter how small, counts for one, must support the resolution, but also that the issue must be supported by states representing 65% of the population. And clearly in that part of the equation, the bigger states carry more weight. But both of those must be met in order for the Council to be taken to have passed, for example, their side of legislation. There are other more complicated forms of voting which it's beyond the substance of this lecture to deal with. But it can be seen that these methods of voting are, at least in part, designed to achieve the same sort of result that operated in the US Senate, thus giving extra weight to the smaller member states, just as the Senate gives extra weight compared to their population to the smaller states of the United States. The European Parliament is more loosely based on proportionality so far as population is concerned, although there is a stipulation that no member state can have more than 96 seats in the Parliament and no member state can have less than 6. And thus, for example, Ireland, which has 13 member states for 5 million people, can be compared with Germany, which has a population of 80 million and is therefore 16 times Ireland, but has 96 seats, which is just over 7 times as much as Ireland. So it's proportionate-ish, but not fully proportionate to population. And thus, one might say the typical voting system of the Council of Ministers is not quite the same as the pure 2 senators per state model in the United States. And the members of the European Parliament are not quite as proportionate to population as the US House. However, both models seem to be efforts in their time and as reflecting the same sort of political balance between states in the US context or member states in the European context on the one hand and a central form of government on the other. But moving to a more legal aspect of the respective regimes, I think I should start with a significant similarity. Both are based on the principle of conferral. The federal government only has authority under the US Constitution if the Constitution itself gives it power in a particular area. The European institutions, likewise, Central European institutions, only have authority if the treaties provide for it. At that level, both regimes are very similar. However, I find quite a significant disparity between the way in which the principle of conferral operates in practice. While not claiming to be a great expert in US constitutional law, I have the very strong impression that a significant element of important constitutional litigation in the United States involves disputes about whether the federal government has the power to deal with certain areas. I suspect not all lawyers on this side of the Atlantic were fully focused on the fact that the Obamacare litigation, which was of course highly controversial, was not about whether the healthcare regime provided for by Obamacare was a good thing or a bad thing or infringed rights or was discriminatory or anything like that, but rather concerned whether the federal government was entitled to enact the Obamacare legislation. Prior to the judgment in that case, perhaps the greatest focus was on whether it might survive by reason of the so-called Commerce Clause and the power of federal government to regulate commerce. But in the end, as we know, it passed by a 5-4 majority, with Chief Justice Roberts siding with the majority on the basis that it was saved by the entitlement of the federal government in the field of taxation. Now, interestingly, the Treaty on European Union now expressly provides for a principle called the principle of subsidiarity. Under that principle, measures should only be adopted by the Central European Union institutions, where the aims of the European treaties require collective action at that level, rather than being left to individual member states to deal with the issue themselves. In other words, the top should only govern where the bottom cannot act effectively. And it's perhaps a surprising feature of European court litigation that there has been no case, as yet, in which a measure has been found to be invalid by reason of breaching the principle of subsidiarity. There would be a great source of potential research to seek to identify the reasons why that is so. Why is it that much of the litigation in the United States in this area centres around the competence of central government, whereas little enough of the litigation in Europe centres around the same things? Perhaps, and it's only a perhaps in my view, it may have something to do with the fact that most European legislation is passed by consensus. So the natural party who might bring the proceedings, being a state or a member state in Europe that is aggrieved by the way in which central European institutions have acted, doesn't exist because that state has itself participated in a consensus process leading to the legislation concerned. And of course, European legislation itself often follows a somewhat tortuous route to consensus. There may be the need to build consensus within the Council of Ministers through negotiations. The European Parliament itself often forms a view through consensus because no single political grouping has a majority or anything like it. And then there has to be a negotiation between the Council of Ministers and the European Parliament. So you have a consensus upon a consensus. And from lawyers' point of view, we sometimes feel that that leads to less precise legislation than one might ideally hope for. But it might be thought that this process reduces the likelihood of a challenge by a member state arguing before the European courts that the measures have been adopted by the Union institutions in a way that breached the principle of subsidiarity. I now turn to the question of courts. At one level, there is a very significant similarity. In the United States, as certainly our American students know, and as I suspect our Irish students also know, each state has its own system of courts, frequently operating with a Supreme Court at its apex, although names sometimes differ with, for example, the apex court in New York being called the Court of Appeals and the equivalent of the major trial court being called the Supreme Court. Obviously, equally this side of the Atlantic, each member state of the European Union has its own legal system. Its own system of courts. The United States also has the federal system, and we in Europe have both the General Court and the main Court of Justice in Luxembourg. But I think there the similarity ends. A most striking difference is the complete separation of federal and state court business in America, with the combination of European and national litigation this side of the Atlantic being conducted in the same courts. Thus, federal issues are addressed at first instance by litigation in the relevant federal district court and can go on appeal to the Court of Appeals and potentially to the United States Federal Supreme Court. However, in Europe, almost all of the litigation involving European law is conducted in the ordinary courts of each member state. In respect of that litigation, the only role of the Court of Justice in Luxembourg is to interpret any relevant issues of European law on the basis of a reference from a national court to the court in Luxembourg. There is a very limited category of European law cases that can start in Luxembourg in the General Court, but they are mainly cases involving challenges to acts of the European institutions themselves. For example, the current major litigation between Ireland and the European Commission over the imposition of a major obligation on Ireland in respect of the taxation of Apple. The Commission took the view that the Irish tax regime amounted to indirect state aid, which is unlawful, in favour of Apple, and required Ireland to raise a vast amount of tax against Apple. Ireland was concerned with that, brought a challenge to that decision of the European Commission before the General Court and succeeded, and there's now an appeal pending before the main court in Luxembourg. But that's a very narrow type of litigation involving frequently member states or affected parties and direct acts of the institutions themselves, the administrative law, if you like. The vast majority of European law issues go nowhere near a European court and are dealt with entirely by the courts of the member states, subject to the occasional reference to the Court of Justice. Perhaps a story may illustrate this very clearly. Some years ago, when I was a High Court judge, I was involved in dealing with significant litigation arising out of the collapse of the empire of a certain Bernie Madoff. There were approximately €1 billion, that's billion and not million, of funds which were meant to be invested in institutions in the Dublin Financial Services Centre. But when people went to look, as it were, the money was missing. And there was obviously significant litigation in the United States about trying to recover as much as possible, but there was clearly going to be a shortfall. And in that context, litigation was commenced in the Irish High Court against certain financial institutions based in the Irish Financial Services Centre, alleging that they were in breach of various duties concerning minding the money concerned. However, I came to learn that there was very similar litigation being conducted in the federal courts in the United States, and in particular in the Southern District of New York. And that district encompasses Manhattan and therefore Wall Street, and therefore frequently involves jurisdiction over very significant financial litigation. And questions arose which could be the subject of perhaps a lecture all of its own, as to the parallel litigation running not between identical parties but very similar parties, involving more or less the same allegations, but one set of proceedings running in the High Court in Dublin and the second set running in the Federal District Court for the Southern District of New York. But for today's purposes, it's perhaps only worth mentioning that I was in that context in regular contact with the federal judge who was dealing with the US proceedings, Judge Berman, and we discussed how to ensure that the two cases ran smoothly in parallel and that there was no conflict between them. And as a matter of interest, at the end of the day, Judge Berman ultimately decided that he would stay the US proceedings in favour of the Irish proceedings on the basis that it was considered that Ireland was, in the context of the issues of the case, a more appropriate or more convenient location in which to conduct the litigation under the so-called forum convenience principle, which, as I understand it, forms certainly part of the law of New York and is also part of the law of Ireland. But for our purposes, perhaps the interesting fact is that those US proceedings were being conducted in a New York court, but one which was part of the federal district court system, which happened to be sitting in New York, not in part of the New York courts themselves. Whereas the Irish proceedings were being conducted in the ordinary Irish High Court, which might the next day be dealing with absolutely plain, simple Irish issues with no European law dimension at all. And there were in the Irish Madoff litigation potentially European law issues, for some of the instruments in which the money was invested were governed by European law. But that fact was not of itself any reason at all why the proceedings would have been commenced in a European court. There is no European court of first instance sitting in Dublin or Berlin or Ljubljana to hear European law cases of first instance. the ordinary courts of Ireland, Germany and Slovenia hear those cases just the same as they hear cases arising from their own national legal order. And in the vast majority of those cases, those national courts will reach a final conclusion applying European Union law without any reference to the courts in Luxembourg at all. I might then move to a more nuts and bolts issue. I think I should share some of my experiences of having been involved in a number of comparative sessions where Irish and US judges and litigators have come together to discuss before panels of students from both the US and from Ireland the relative ways, similarities, differences between the conduct of litigation in our two jurisdictions. In some ways, the broad drift of our systems is very similar. Cases are heard in a court before a judge, sometimes with the aid of a jury. By and large, on the basis of witnesses giving evidence and being examined and cross-examined and re-examined and conclusions being reached. But the differences, I think, are also significant. Ireland has largely abandoned jury trials for almost all types of civil actions. On the other hand, I understand it's possible in a number of United States states for the accused in a criminal case to opt for a so-called bench trial, which is conducted before a judge alone without a jury. This can be so even where the offence alleged may be serious. In Ireland, a trial by jury is required by the Constitution, except in minor cases, which can be tried summarily in our lowest tier court, the district court, and in the limited category of case that goes before the non-jury special criminal court. So an accused charged with a serious offence in Ireland can't opt for the equivalent of a bench trial. So perhaps it might be said that the criminal jury trial is even more embedded in the Irish legal system than in the systems of at least some US states, whereas the civil jury trial, which is common throughout the United States, is now almost a thing of the past in Ireland. Another significant difference is the extent to which evidence in civil proceedings is rehearsed in advance through the deposition system in the United States, where there is no equivalent in Ireland. The first time, for example, a defence lawyer in civil proceedings in Ireland gets to question an important witness for the plaintiff is at the trial when that witness is called to give evidence. We do sometimes, in certain types of cases, have procedures where some level of disclosure has to be made in advance, such as the presentation of a witness statement of what the evidence in chief of the witness is intended to be, or in the case of expert testimony, a report setting out the expert opinion of the witness who is going to give that testimony. But in terms of the entitlement of the other side to question witnesses, to see whether what you think they might be going to say actually turns out to be what they will say, and to test whether that testimony is likely to stand up. The first time that opportunity arises in Ireland is at the trial itself. And I suspect there are advantages and disadvantages to both systems. But I'll end this lecture with repeating a comment that was made at one of those sessions by a prominent Illinois litigator, who was asked by one of the students how he would feel if he was required to conduct his litigation in what we might call the Irish way, without deposition. He gave a typically succinct answer, which I think I can repeat in full. He said, "I'd be really scared." Thank you very much.